Alliance for Finance. Thank you all for attending, and thank you to our good friend Tony Rippon from Morrish Solicitors for providing the first update of the year for the Alliance for Finance and its affiliates. There'll be time for any questions at the end of Tony's presentation, so we welcome you to add your questions to the chat or the Q&A facility just as we go along. Tony, I'm sure this is going to be an interesting update, and I'll hand over to you so you can get started with your presentation. Thank you.
Thank you. I'll just share the screen so you can see my slides before I get going. So hopefully you should all now be seeing the Employment Law update as a first screen. Is that showing for everyone?
Yeah, I can see it.
Great,
yeah.
Thank you. Well, thank you for inviting me here today to do this. The Employment Rights Bill, I'm sure, has not gone unnoticed. It's a huge topic. So I'll try and cover it. There'll be more areas that we go into in more detail than others. But like you said, if there's any questions, I can deal with those at the end. I'm sure the firm's well known to you, so I'll skip through our other services and everything about us today. And what we'll be looking at is a recap of the key changes, which we'll go through in alphabetical order. And I'll just cover that to start with so you see what they are. And then we'll look at those in more details and the latest developments and what we know now and what we don't know now, because obviously certain parts are coming in sooner and clearer, and other parts are still subject to more regulations. But a bit of background first as to how we got here. The Employment Rights Bill, it implements the plans that were outlined in the Labour Party's pre-election, the Labour plans to make work pay, delivering a new deal for working people. And following the election, the bill was listed in the King's Speech. That was in July last year. And the government was very committed to introducing this bill within their first 100 days of entering their office. So there was a lot of work done very quickly on it, which is possibly why some of it is still to be seen what will happen. Now, the government published a policy paper, which was known as the Next Steps to Make Work Pay, and they introduced the bill itself on the 10th of October 2024. And it's gone through various stages, and there's been a response on the 4th of March 2025, which followed significant amendments. It's passed its third and final reading in the Commons on the 12th of March, and on the 29th of April was the first sitting in the committee stage in the House of Lords. Now, as of yesterday, there's been 11 House of Lords sittings, and that's all that was scheduled so far. But it's unknown if more will need to be scheduled. We've not got any real reports from yesterday's sitting as of yet, but it's known that the government doesn't want this bill to be passed before Parliament's summer recess, which begins on the 22nd of July. So watch this space, really. A lot could be actually coming in very quickly. So what we'll look at today is, as it reads, collective redundancies, discrimination, which is sexual harassment and also third-party harassment, dismissal and re-engagement, families and pregnancy, the Fair Work Agency, changes to flexible working, looking at public sector outsourcing and collective bargaining. We'll look at changes to statutory sick pay, trade union law and various changes that come in relation to that, in changes to the tribunal time limits, changes to the way unfair dismissal claims can be pursued with day one rights. We'll look at working time regulations and obligations on employers in relation to those, and also changes in respect of 0 hours contracts or low hours and agency worker contracts. Okay, so under TULCRA, where an employer proposes to make large-scale redundancies of 20 or more employees at one establishment within a period of 90 days or less, it has to consult on its proposal with representatives of the infected employees, which there's collective bargaining in place. It could be trade union representatives or employee forums. And they also need to notify the Secretary of State. So that's collective redundancies. And I'm sure most of you will know that there's long established case law from the Woolworths case that an establishment is seen as the local unity or entity to which workers are assigned to carry out their duties. So that means that there needs to be 20 or more working generally or assigned to one physical work location, as opposed to across the company as a whole, if they've got various different locations. Now, the government pledged to strengthen redundancy rights and protections. And as this bill was originally published, the right to redundancy consultation was to be determined by the number of people impacted across the business as a whole, rather than in one establishment, which would greatly increase the amount of times when this needed to take place in redundancy scenarios. And it was going to do that by amending section 188 of TULCRA by removing the words at one establishment, which would have effectively reversed the Woolworths decision. And it would have been so that the number of proposed dismissals was going to be aggregated across the entire workforce. But we now know, unfortunately, that this won't happen. One of the various things that's been watered down or changed along the way. However, there still is going to be changes, but because of concerns raised by large companies who operated over multiple sites, the government did abandon its initial plan to remove that one establishment. And under a new clause, 27 of the Employment Rights Bill, collective consultation under the section 188 of TULCRA that I've just described will be required where an employer is proposing to dismiss as redundant, still within a 90-day period or less, either 20 or more employees at one establishment, which is currently the situation, or now also at least the threshold number of employees which is to be specified in regulations. Now, what we do know is that that threshold number that is to be set may be either a specific number, as in 20 or more, a percentage of employees, or it might be determined otherwise, but it can't be less than 20. So while we know that redundancy consultations are likely, or hopefully likely, subject to what's to be agreed, going to trigger collective consultation more often, we can't yet know the exact numbers and don't know the exact numbers of when that's going to actually take place. It does seem that this might have been kicked into the long grass for the time being, so we'll just have to wait and see. There's certainly no imminent major changes coming into effect, just the ability for the changes to be introduced. But there is, however, some positivity to this in respect of compensation. So the government issued a consultation seeking views on introducing changes to the level of the award that can be given by tribunals when there has been a breach of section 188 of TULCRA, so there hasn't been collective consultation. What they could have done was remove the cap and compensation available for these protective award claims and left it purely to the discretion of the tribunals to determine what would be a just and equitable level of compensation on each case, subject to the facts of that case. Disappointingly, the government has decided not to amend the provisions to remove the cap on compensation for protective awards, but they have doubled the award. So currently, it's 90 days pay, and that's gross pay, is the maximum a tribunal can award for a protective award claim, and that's set to increase to 180 days pay. What will be left is the tribunals will still have the discretion to vary that award on a just and equitable basis. So that's not to say that there will be an award of 180 days each time, just that that's the maximum. It will be a scale from 1 to 180, subject to what's happened. And the code of practice and dismissal will still be updated to reflect new changes. From a practical perspective, there's no discussion about how they'll change compensation that's actually paid out under the insolvency service, because the majority of protective award claims in these scenarios often arise from companies that have actually gone into administration or liquidation, and there's been mass immediate dismissals. And whilst you might get a 90-day award at a tribunal, there's no solvent company to seek payment for that. So what you do is those individuals go to the insolvency service, where there's a cap of 8 weeks pay, subject to a weekly cap. So there's no discussions of changing that. So the realities of it is yet to be seen. So there's also changes to discrimination law, specifically sexual harassment. Now, there's already been some quite recent changes on this area. So on the 26th of October last year, Section 40A of the Equality Act was introduced by the Worker Protection Amendment of Equality Act, known as the Worker Protection Act. And it requires employers to take reasonable steps to prevent sexual harassment. Now, this hasn't introduced the ability to bring a standalone claim if it's felt that there's been a breach of this. But similar to if you're bringing claims and arguing that there's a breach of the ACAS code on grievance and disciplinary meetings, if a tribunal finds that there is a breach of a sexual harassment claim that might have been brought, and when looking at that, they also consider this guidance as a breach of this as well, they've got the ability to uplift compensation by up to 25% on top of the award that would have been made for the sexual harassment claim. It also brought in the power for the Equality and Human Rights Commission to investigate and take enforcement action if it was felt that there was a breach. Now, that can be done even if a sexual harassment claim isn't pursued. So that it did strengthen what wasn't there, should we say. But now, Clause 19 of the Employment Rights Bill will be amending Section A, and it will amend it to include all reasonable steps to prevent sexual harassment. So currently it says the employer must take reasonable steps. Now it's all reasonable steps, which was actually the original intended wording of the Worker Protection Act when it was trying to be brought in before that was removed by the House of Lords. In addition, under this amendment that's going to be brought by the Employment Rights Bill, as well as the employers being under a duty to take all reasonable steps to prevent sexual harassment, this will include third-party sexual harassment, crucially, and it will prevent third-party harassment in relation to all other protected characteristics. So it's really very far-reaching and very positive progression. And it will mirror the amended duty of what's known as the all reasonable steps defence. So currently, essentially, even if harassment has occurred and a claim is pursued against it showing that harassment took place, the employer won't be liable for it if they can show that they took all reasonable steps to prevent it. So essentially, that's what needs to be done in these scenarios. Now let's look at the third-party harassment in a little bit more detail, because that really is a crucial development. Section 40, subsections 2 to 4 of the Equality Act sets out those provisions for third-party harassment. Now they've actually been there since the Equality Act came in, and under those, for an employer to be liable for third-party harassment, it was required 3 prongs. So the third party had to harass an employee or a job applicant in the course of their employment, and the employer had to have failed to take such reasonable steps as would have been reasonably practicable to prevent that harassment, and the employee had to know that the employee or job applicant had been harassed on at least 2 previous occasions by a third party. Didn't matter if it was the same third party, just that it had already taken place twice before. So that was what originally came in the Equality Act, which some of you will recall was then repealed in October 2013. And now what we've got is the reintroduction of this, and it's actually a better protection that's been reintroduced. So clause 20 of the Employment Rights Bill specifically what reintroduces the employer liability for third-party harassment, and as I said, it's to all relevant protected characteristics. Now, an employer under this new change will be prohibited from harassing their own employees or job applicants, and also they must not permit a third party to harass their employees or job applicants. Now, it'll be determined that an employer will have permitted a third party to harass its employees or applicants if both of the following apply. The third party harasses the employee in the course of their employment, as you'd expect, and the employer failed to take all reasonable steps to prevent the third party from harassing the employer in the course of their employment. That's it. That's what it states. So as you can see, the duties become more onerous than the previously appealed one, because there's now no requirement for the employee to have been harassed by a third party on at least 2 previous occasions, or for the employer to have had knowledge of that. So in pursuing these claims, the employee, if they're going to be successful, will only need to be able to show that the third party harassment took place during the course of their employment and that the employer failed to take all reasonable steps to stop it. Now, this is likely to have far-reaching impact for particular employees, especially those that are operating in sectors where staff frequently come into contact with third parties. Because currently, it seems that any finding of third-party harassment will almost inevitably mean that those employers failed in their duty to take all reasonable steps to prevent it. Employers obviously have far less control over the actions of third parties than they do over staff that work for them. So it's potentially something that needs to be and probably will be considered by a tribunal when looking at the facts of particular claims. Because if the harassment provisions of the Employment Rights Bill are passed in their current form, it really will make it quite tricky for any claims to be defended if harassment has actually taken place by third parties. So this is one where I think it remains to be seen whether further amendments are going to be coming in to address this. We shall have to wait and see. Still on that though, I should add currently the reasonable steps employers will take to comply with the forthcoming duty to take reasonable steps are set out under section 40A. But they're not actually prescribed, as in it's not set out in stone what those steps will be. What there is non-statutory technical guidance provided by the Commission, and also an 8-step guide Some of you might be familiar with that already if you've had any training on the new sexual harassment legislation. Now, guidance on meeting all of the reasonable steps defence under section 109, the one I mentioned before, which has been mirrored here in relation to sexual harassment, is also set out in the Commission's technical guidance, but it is, as it says on the tin, just guidance. Now, clause 21 of the Employment Rights Bill, which introduces a new section 40B of the Equality Act, may mean that regulations will specify what are to be regarded as reasonable steps that employers should take or fail to take. So it might be that they become prescribed as opposed to just guidance. I think what we do know is that to comply with its duties that there'll be a need to comply with its duties to take all reasonable steps to prevent the harassment by looking, as I said, at the all reasonable steps defence that's currently in place. And this will include the need to look at and have risk assessments to put in place sexual harassment plans or policy to report incidents of sexual harassment and have clear reporting channels so that staff can do that if they've got concerns, and also details of how complaints will be handled should those complaints be raised in an effective and transparent manner. And clause 22 of the Employment Rights Bill also amends section 43B of the Employment Rights Act. And that's so that it will now be a protected disclosure for an employee to report that sexual harassment has occurred, is occurring, or is likely to occur. So this is now providing whistleblower protection to those staff that actually come forward and report sexual harassment, obviously with the whole hope that that will encourage it to take place. Now, with that whistleblower harassment, workers will therefore get protection from detriment, or should I say being subjected to a detriment for having made that disclosure, with employees also being protected from a detriment and also from dismissal for reporting the harassment. And a further impact of this is that means that those disclosures will actually be excluded from confidentiality provisions in the usual way that protective disclosures are. So, such as in contracts of employment or in settlement agreements. So that's all really positive steps to try and stamp this out in the workplace. And further, the bill is also opening up the possibility of there being interim relief in these scenarios. So that for those of you that don't know, currently, if there's an unfair dismissal claim that's going to be pursued because an employee has been dismissed, they have in a short time frame, 7 days of dismissal, the ability to seek interim relief from the employment tribunal. And it's quite a high threshold that needs to be overcome, but if you can be successful in showing that it's likely that the dismissal would be found to be unfair, in certain cases, I should say not all unfair dismissals, certain cases of unfair dismissal, the tribunal has the power to award that essentially no dismissal will actually take place, so you're reinstated temporarily, or if the employer is unwilling to do that, to at least continue to pay their wages until there has been the unfair dismissal claim itself has been heard to find out whether there's been an unfair dismissal or not. And the bill is talking about opening this up so that if there's any, should we say, unfair dismissals that have arisen because of your reported sexual harassment, that they would have that protection, that ability to seek interim relief in those circumstances. Also looking at discrimination still is the introduction of equality action plans. So this is one where we're going to wait for future regulations to see the details, but we know that they will require employers with 250 or more employees to develop and publish equality action plans, and that's from clause 31 of the bill. And there'll also be an advancement of equality between male and female employees, primarily really looking at including addressing the gender pay gap, and also in supporting employees going through the menopause, given the large number of people that are losing employment as a result of that. But as I said, not a lot is known on this, and we'll have to wait for future guidance. Now, this is another big one. The government pledged that the bill would abolish both fire and rehire, as well as fire and replace. So that's where a new workforce is engaged to replace the old one, as opposed to the staff being re-engaged on new contractual terms. And this measure was widely trailed as one of the key election promises as part of the pledge to tackle one-sided flexibility. The practice of fire and rehire has received lots of negative press over the years, and there's been a number of high-profile cases. You'll be aware of the dismissal of 800 employees on P&O ferries in 2022, where they were all replaced by lower-paid agency staff. There was also a Tesco case where they unsuccessfully sought to use the practice to overturn a previous agreement to permanently pay staff a rate of pay for their agreement to relocate. It's not yet clear how restrictively employment tribunals might interpret these new provisions. The message that we're getting is that the fire and rehire will only be acceptable where there is genuinely no alternative, but it maintains that businesses will still be able to restructure where needed to remain viable and preserve the workforce. Now, there's a new section 104I of the Employment Rights Act, which is going to make it an automatic unfair dismissal. So one where you don't need 2 years qualifying service. If you dismiss an employee for refusing to agree to a change in the contract of employment, or to enable the employer to employ another or re-engage the employer under a varied contract of employment to carry out the same or substantially the same duties. So with that being an automatic unfair dismissal, there's no minimum qualifying period, so there's no need to have 2 years service, which is something we'll look at in the broader context of unfair dismissal soon. But there is going to be an exception to that. And where an employer can show evidence of financial difficulties and demonstrate that there was a need to make the change in contractual terms, which couldn't be reasonably avoided, then the dismissal won't be found to be automatically unfair. But to show that, it needs to be determined that the reason for the variation of the terms was to eliminate, prevent, or significantly reduce or significantly mitigate the effect of any financial difficulties which, at the time of the dismissal, were affecting or likely in the immediate future to affect the employer's ability to carry on the business as a going concern, or otherwise to carry on the activities constituting the business. And in all the circumstances, the employer could not reasonably have avoided the need to make the variation. So that's the statutory test that needs to be overcome for this exception to apply. And it's expected that it will only apply in very limited situations. So looking at that, the employer would need to show that its ability to continue in business was actually at risk in the time or would be in the immediate future. So it was not enough to show that the change was intended to avoid issues more speculatively. And also looking at the test that's applied, the usual range of reasonable responses tests, which we'll be familiar with for unfair dismissal claims, won't apply in these scenarios. A tribunal will instead need to consider whether the employer could reasonably have avoided making the contractual variation. Currently, they only look at if it was reasonable on that band of reasonable responses test. Now, currently, when looking at the current reasonable responses test, it's whether the employer had sound business reasons for imposing the change, and the change does not have to be crucial to the survival of the business. Also, crucially, tribunal doesn't go behind the underlying business rationale that's been provided for the contract variation, or critically scrutinise the business decision to vary those terms. But under this change, there is a significant shift. Tribunals need to go behind the underlying business rationale, and they need to make findings as to whether that statutory definition that's listed on the slide is met regarding the employer's financial position, its ability to continue as a going concern, and whether the contractual variation could reasonably have been avoided. Now, this is a new area for ETs, but it does prevent them with a greater power to really look at the nuts and bolts of the reasons that's given by the employers who might otherwise have been able to avoid successful claims. But it is outside of their usual remit, and there's going to be a need for quite specific evidence to be pursued and presented here to actually be able to make these determinations, which ultimately is likely to lead to longer, more expensive and more complex claims. But of course, these scenarios will often be looking at the dismissal or re-engagement of a large workforce, so all makes sense. Now, case law is needed to determine how tribunals are going to apply these factors in practice, and weight is going to be given to each and every other factor to be taken into consideration. But if the criteria of the new Section 104I is satisfied, the ET still needs to assess whether the dismissal was fair in all of the circumstances, for all of the reasons that are set out there, including any consultation carried out by the employer with the employee, if the trade union is recognised, and any consultation has been carried out there by the employer with that trade union. If the trade union is not recognised, if any consultation has been carried out by the employer with any other person representing the employer's interests, such as an employee forum, if anything's been offered to the employee by the employer in return for agreeing to the variation, or any other matters specified for the purposes that are in regulations. Now, there's also a statutory code of practice on dismissal and re-engagement, which was actually written by the previous Tory government, but only came into force in July last year after our current Labour government came into power. And the process for employers to follow when making changes to one or more of its employees' contracts of employment, and the employee envisages that, are set out there. Now, employment tribunals are required to take COVID into account when considering any compensation awarded in these relevant types of claims, including unfair dismissal. And if they feel that it hasn't been, or there's been a breach of the code, they've got the power to impose an uplift of up to 25%, or a reduction as well, similarly, if they think that's just inequitable. On the 4th of March, the code was updated to reflect Bill's changes and seeking views. And one of those is to do with the increase of compensation for protective awards to double it, as we covered earlier. So now looking at the changes in respect of families and pregnancy, the government said in the Next Steps paper that it intended to make it unlawful to dismiss employees who had been pregnant within 6 months of their return to work, save for in specific circumstances. Now, regulations are still awaited to define what those specific circumstances will be, so we don't know what the exceptions are. The maternity leave, adoption leave, and shared parental leave regulations 2024 already make detailed provision for redundancy dismissals during pregnancy. We shouldn't expect to see any significant changes in relation to the definition of the protected period of pregnancy or how that existing redundancy protection operates. Now, the relevant provisions of the Employment Rights Act 1996 in respect of each of the following types of statutory family leave are intended to permit regulations to be made about dismissals, crucially after a period of such leave, rather than just during the leave period, which is currently the case. And that includes maternity leave, adoption leave, shared parental leave, the extended paternity leave in cases of bereaved parents, that's not yet actually in place, and the neonatal care leave, again, which is not yet in force, but it will extend that window for all of those. With the existing powers in relation to redundancy also extended to include dismissals for all other reasons. And this includes the power to set out in regulations how the protected period of pregnancy is to be calculated, provisions requiring the employer to offer alternative employment, provisions stipulating that failure to comply with regulation will result in the dismissal being treated as unfair, and provisions for the protected period of pregnancy to commence after the pregnancy has ended to allow, for example, a scenario where if somebody's miscarried before informing her employer of pregnancy, she's still able to access that protection. Also, paternity leave is going to become a day one right for eligible employees. Currently, you have to have been there for 26 weeks at the relevant date before you qualify for that. Unpaid parental leave will also become a day one right for eligible employees. Currently, that requires a full year's service before you can qualify. And the next steps paper confirmed that the government plans to conduct a review of parental leave. We've got a time frame that we're still awaiting on, and the existing rights of 2 weeks parental bereavement leave following the death of a child under 18 or a stillborn are going to be extended, and there's going to be more general entitlement known as bereavement leave. It'll apply to the loss of a wider group of persons, and it's also going to be a day one right. Regulations will also specify that relationships with a person who has died that will qualify an employee to take bereavement leave, but we don't yet have those, so we don't know how wide it's going to be. And they'll ensure that where the person who has died is not a child, the minimum period of leave will be 1 week, and the person will be entitled to leave in respect of each person who has died if more than one. Now, statutory parental bereavement pay will continue to be payable where a child under the age of 18 has died, but provision is not made for the wider class of bereavement leave to be paid. So lots of changes that are going to be coming in on this, a lot of which, however, we don't have the finer details of, but all good, positive changes. Now, there's also going to be a Fair Work Agency being set up, which is going to bring together the existing enforcement functions of HMRC in relation to the national minimum wage, the Employment Agency Standards Inspectorate, and the Gangmasters and Labour's Abuse Authority. The government intends the Fair Work Agency to be a strong and recognisable single brand, so individuals know where to go for help and to lead to a more effective use of resources. And the agency will take a balanced approach with better support for the majority of employers who want to comply and tough action against those who won't. However, whether the agency succeeds in improving enforcement is going to depend on the level of financial resources that it's allocated, I imagine, and none of that is yet clear. It's also not known when it will be established, although it seems that it might be a fair few years before it's fully operational. It will have responsibility for enforcing the following labour market legislation: the Employment Agencies Act, payment of statutory sick pay, the obligation under Part 2A of the Employment Tribunals Act to pay financial penalties for failure to pay sums that have been ordered under tribunal awards of cot-free judgments. As I've said, the payment of the national minimum wage, also payment of holiday pay and rolled up holiday pay, and certain provisions of the Modern Slavery Act. It will also have the power to require an individual to attend a meeting and answer questions, as well as provide documentation by a specified date, so helping them do their investigations. Got the power for enforcement officer to enter premises to inspect documents and computers. That power is to enter any premises subject to a warrant for a dwelling. It can require undertakings to comply with labour market legislation and or make orders to comply. It can serve notices of underpayment and require payments within 28 days, such as for statutory sick pay or holiday pay. And also there can be payments as a penalty that are awarded. And it has the power to bring ET proceedings. So it will, in due course, seem to have quite a lot of additional powers and protections. Now, turning to flexible working, there's already was a recent amendment in April last year, meaning that employees now have a day one right to make a request for flexible working under the current scheme. And an employer can refuse a request, as many of you will know, for one or more of certain prescribed reasons set out in Section 80G of the Employment Relations Act. Often employers will point to more than one of these reasons and say that's the reason that they just simply can't bring the change in. Now, the wording of Section 80G 1B suggests that the test is a subjective one on the part of the employer. So essentially, if the employer considers that it's satisfied that it applies, it does, which doesn't really give any question of reasonableness to be taken on whether that, which doesn't really allow a tribunal to assess if that is reasonable or not. And what the government's pledged to do is to make flexible working a default from day one, except where it's not reasonably foreseeable. And the bill seeks to do that by introducing a test of reasonableness. So does not make flexible working the default position from day one. So there is still a need to request it, but it does make it harder for employers to refuse those requests. Firstly, the current right to request it, which can be refused on one of those grounds, the employer will only be able to rely on one of the statutory reasons to refuse the request, rather than just picking a number of them. And also, they'll have to show that it's reasonable to rely on that ground, which is going to make it more difficult for the employer to simply refuse that request and perhaps just pay lip service as they currently are, and actually gives tribunals the power to actually have a greater investigation into if it was a legitimate reason to rely on the one that the employer was pointing to if they were refusing such a request, and allows all those arguments about reasonableness of that to be explored. One change that hasn't come in, though, is anything to do with compensation, and that's currently 8 weeks' pay if it's found that there has been a refusal to follow this reasonable request. And there's also thoughts that perhaps that really means that it's still not got much teeth in respect of what can be done if an employer refuses it. But nevertheless, these are good changes that are in place. Public sector outsourcing and collective bargaining is also set to change. It's going to amend the Procurement Act 2023 to protect transferring workers on outsourcing contracts, as well as those working alongside them. So it's going to reintroduce the principles of the two-tier workforce code to prevent contractors from direct hiring people and treating them differently from an incoming public sector workforce. And it allows the government to make regulations and a new code of practice on how to address this scenario. But again, as of yet, we don't yet have the details on this particular area. Statutory sick pay, that's going to become payable from day one of sickness absence, removing the current 3-day waiting period. It's going to remove the lower earnings limit, and it's going to introduce a system to provide fair earnings replacement for people earning below the current rate of statutory sick pay. The weekly rate of statutory sick pay to be the lower of the prescribed weekly rate and prescribed percentage of the employee's normal workly earnings. And that prescribed percentage is going to be 80% of normal weekly earnings. So there's no longer going to be the requirement that employees earn more than the lower earnings limit to become eligible for this pay. Now, the government, looking at the trade union changes, the government has committed to repealing both the Strikes Minimum Service Levels Act and the Minimum Service Level Act 2023. Now, the Trade Unions Act 2016 won't be repealed in its entirety, but nearly all of the restrictions placed on industrial action and picketing will be removed. But the introduction of the time-limited mandate for industrial action following a ballot is going to remain. Other changes from the Employment Rights Bill include the promised rights to a statement of trade union rights and for trade unions to access workplaces, which has been described by critics as the union's right to roam. It also includes simplification of the rules on trade union recognition, for which there's currently quite a complex statutory process that must be completed, where employers refuse to agree to voluntary means. The trade union officials and learning representatives also will have a right to facilities, as well as time off, and similar rights will be introduced for equality representatives now. Individuals will benefit from strengthened protection from blacklisting. And we're going to see the introduction of protection from detriment on the grounds of industrial action, where there currently is a gap of protection in UK legislation. And we'll see increased protection from dismissal when participating in protected strike action or action short of strike. Now, Clause 75 of the Employment Rights Bill repeals the minimum service levels for strikes in relevant services. That's health, transport, education, fire and rescue, border control, nuclear decommission and radioactive waste management services. And that repeal will take place on the day that it receives royal assent when it comes into force. And there's also going to be a statement of trade union rights. Now, this is going to require employers to give workers a written statement advising that they have right to join a trade union. And this is to be done at the same time as when they provide the workers' Section 1 statement they need to provide, and also at other prescribed times, which is yet to be determined by secondary legislation. We know that it will prescribe that the information must be included in the statement, the form which the statement must take, and the manner in which the statement must be given. And if there's a failure to do any of that, then it's addressed in the way that it currently is if there's a failure to provide a Section 1 statement of employment. Also, as said before, there's going to be the right of access, or the right to roam, as it's been called. Now, these provisions, which are supported by regulations, will enable listed trade unions and employers to enter into access agreements for union officials to access the employer's workplace for the purposes of meeting, representing, recruiting or organising workers, or facilitating collective bargaining. But it does expressly say it's not for the purposes of organising industrial action. Now, for this to happen, the union needs to present an access request, which might be on one or more occasions, and it needs to propose the terms for access. Now, once that's presented to the employer, they may issue a response notice to the union before the end of a response period. Now, if the employer responds, there then is a negotiation period in which parties are to agree written terms on which those officials will have access and for what reasons. However, if that's unsuccessful, those negotiations, or if the employer doesn't respond with a response notice within the negotiation period, then that leaves the union with the ability to bring an application to the Central Arbitration Committee to make a finding on it. And the CAC will determine applications by taking account of the access principles, and it will determine if there's been a breach, and it will allow appeals on a point of law to be heard by the Employment Appeal Tribunal. Recognition has also been addressed. So currently, for a trade union's application to the CAC to be accepted, that's an application for statutory collective bargaining rights of a prescribed bargaining unit, if it can't be done voluntarily. It needs to meet a number of admissibility requirements, including that the CAC must itself be satisfied that at least 10% of the workers in the bargaining unit are members of the union. Now, clause 47(1) of the bill will insert a new paragraph, and it will mean that the required percentage reach 10%, but the regulations may amend that so that the required percentage is a percentage that's never any greater than 10% and never any less than 2%. So you can see there's the ability to have quite a sliding scale of that in the future to bring it down to as low as 2%. Currently, in addition to being satisfied that at least 10% or less to be determined of the workers in the bargaining unit are members of the union, the CAC also needs to be satisfied that a majority of the workers in the bargaining unit would likely be in favour of the union being recognised to conduct collective bargaining. That means that where the CAC has ordered a recognition ballot to be successful, the union must be supported by both the fact that a majority of the workers voting support it, and at least 40% of the workers within the bargaining unit support it. Now, this is going to remove the 40% threshold from that recognition ballot, and it will amend the requirement so that now only a simple majority of those voting is needed to get over that hurdle. And the bill's also going to extend the application of the Code of Practice on Unfair Practices to the entire recognition process. And another thing is that the number of workers that are actually included in that bargaining unit is now going to be capped at the point the application is made by the union. So any who join the bargaining unit after the application has been received by the CAC are going to be unable to vote in any potential ballot that might arise, which will prevent any unscrupulous employees who thought they might temporarily engage agency staff for the sole purpose to vote against these things from being included in those ballots. And if it's deemed that there's any unfair practice in regards to any of that, claims are to be directed to the CAC. It also looks at facilities time, as I said. So currently it provides that an employee may, sorry, when I say currently, the current changes that are proposed provide that an employee may complain to an employment tribunal that their employers failed to permit them to take time off for trade union duties, being expanded to include a new right, I should say, for the employee to complain that the employers failed to provide them with facilities. Now, we've got current ACAS guidance on that, the trade union representation in the workplace, which suggests that facilities should, if resources of the employer permit, include accommodation for meetings, confidential space where an employee can meet their representative for discussions, access to a telephone and other communication media used or permitted in the workplace, such as email, intranet and internet, and also the use of notice board. But this is all going to be addressed by an ACAS code. Section 168A9, which currently provides that an employee may complain to an ET that their employers failed to permit them to take time off for trade union learning representative duties. That too is what's going to be expanded to include a right to complain about this facilities point. So essentially, it's going to allow the employee to complain that they have not been permitted to take time off for trade union learning representative duties, and also for being provided with the facilities time or the ability to have facilities such as meeting rooms, confidential spaces, telephones, etc. Now, industrial action is another thing that's looked at. The turnout and support thresholds of 50% are going to be removed, but it's paused at the moment to align with new e-balloting rules, which are yet to be determined. Now, the 40% support threshold in public services will be removed, and they're going to simplify the provision of information to employers in the notice of ballot, notice of industrial action and voting papers. Currently, it's quite specific and detailed rules that need to be followed, and if there's any errors along that, it can invalidate the process. There also the 10-day notice of commencement of industrial action is going to be the case. Instead of having to now instead of providing 14 days, we now only need to provide 10 days notice. If all the steps are gone through and there is a mandate for industrial action, currently that's only for 6 months. That's going to be extended to staying in place for 12 months, reducing the need to keep doing this. And a working group has been launched to consider the rollout of e-balloting for trade union statutory ballots. I mean, it seems to me almost unquestionable that this day and age, e-balloting should not be available for this scenario. But again, we've got critics who are referring this as the swipe to strike. So we'll yet to see what comes from that consultation. Now, some of you might know about the Supreme Court's decision last year in the Mercer case, which essentially showed that there was a gap in UK legislation in that Tulcra failed to provide any protection against sanctions short of dismissal that were taken as a result of trade union members taking part in lawful strike action. And this has been addressed in the Employment Rights Bill. So there's going to be a clause 73 of it, which will insert new legislation into Tulcra to remedy this gap and provide that much needed protection from detriment on the grounds of taking part in industrial action. Now, an employee taking part in industrial action can also bring a claim for unfair dismissal, and the claim will be regarded as automatically unfair where the reason, or if more than one, the principal reason for dismissal is that the employee took protected industrial action, and one of the following applies. The date of the dismissal fell within a protected period, which is usually 12 weeks from the day the employee first took part in the industrial action. Date of the dismissal is after the end of, but if the date of the employee dismissal is after the end of the protected period, and the employee had stopped taking protected industrial action before that. Now, this clause 60 of the Employment Rights Bill will remove the need for that protected period in these types of claims, which will mean that an employee will still be automatically unfairly dismissed, so long as the reason, or the more than one, the sole reason for the dismissal is that he took part or she took part in protected industrial action. There's no longer a need to look at that 12-week window, which previously would allow employers to escape it if they should be, say, held off from sacking the employee until it had expired. So again, it's all positive changes that are increasing the protection available to trade union members that want to take part in legitimate strike action. Time limits is also a big one that's been looked at. Broadly, there's going to be an increase of them from 3 months to 6 months, which for me is a very positive and much needed change. Although it seems that that's not going to include claims for breach of contract arising or outstanding on termination. It's unclear if that was actually an intentional exception, if that will be remedied in due course, or if that is simply what the idea behind this was. Now, unfair dismissal, there's also various changes. At the moment, you'll be aware that employees must have 2 years of qualifying service to gain the right to bring an unfair dismissal claim, unless they're able to bring one of the automatic unfair dismissal claims on various statutory grounds, which has said it's going to be increased, hopefully to include whistleblowing for sexual harassment purposes. Now, unfair dismissal under the new bill will become a day one right for employees, which is subject to a new modified, what's known as light touch dismissal procedure, which is to be applicable in most cases during an initial period of employment. Now, much of the detail about this is going to be in regulations and is yet unknown, but it's still going to represent a huge change in the unfair dismissal landscape. There's no doubt about that. And the next steps paper confirms that these reforms will take effect no sooner than autumn 2026. It's not going to be immediately when the bill comes in, and that's for purpose to allow for full consultation with employees and to allow them to prepare and adapt for these changes. So until then, we're still stuck with the 2-year qualifying period. Now, what the paper does make clear is that this doesn't extend to workers, so it still is only unfair dismissal in respect of employees. It doesn't address, should we say, that gap of the middle ground of workers. Now, one key point to take from this, though, a really positive point to take, I should add, is that this could have been done by varying the period of qualifying service simply by passing secondary legislation. And if doing that, it would have been much faster and easier for the government to bring this in. But they've chosen to do it by way of primary legislation, a much longer process. But the positive upside of that is that that means that any future government aren't able to simply pass regulations to increase the qualifying period again if they'd wanted to. They'd need to go through much more rigorous processes to try and undo this. The way it makes these changes by inserting a new section 108A into the Employment Rights Act, and that ensures that this applies from day one, but it also makes the ability, so it also means that employers won't yet be able to bring an unfair dismissal claim if they haven't started work, which is a technical necessity because of the way the law is currently drafted. Now, of notice, what needs to be taken on board is that this change with regards to the ability to bring unfair dismissal claims from day one and this light touch approach, if it's in a particular period of time, won't apply to the automatic unfair dismissal cases, as it still can be brought. So if you're still able to bring an unfair dismissal claim on an automatic ground, there won't be this light touch available, and it will be the current legal tests that are used to determine whether those claims succeed or not. And those types of claims include whistleblowing, trade union grounds, and as we see, that will then hopefully extend to whistleblowing for reporting sexual harassment or dismissal relating to political opinions or affiliation. Now, looking at this initial period of employment point, this light touch approach that might be taken on these unfair dismissal claims, that's only going to be the case if both of the following criteria is satisfied. First being that dismissal occurs during an initial period of employment, or the employer gives notice of termination before the end of that initial period of employment, and the last day of employment is going to be within 3 months of the initial period of employment. And also, if the principal reason for dismissal given by the employer is one of the following fair reasons, being capability, conduct, some of a substantial reason, but note that it doesn't extend to redundancy dismissals. So that's actually excluded from the new provisions, meaning there's no right to be unfairly dismissed. Well, sorry, there's no right to this new procedure to be applied where individuals are being dismissed for redundancy purposes. So, in summary, the light touch procedure of dismissals is only the case if the reason given isn't that of redundancy, and if the dismissal itself is going to come into effect within the initial period of employment. Otherwise, all of the usual procedural rules we already know will apply. What's also going to be looked at is the implementation of stricter things around working time records. There's going to be new obligation on employers to keep records related to compliance with annual leave, as well as with regards to pay that's given for annual leave. And this is that records need to be kept for 6 years of whether a individual is entitled to annual leave, and if so, their entitlement to pay for that annual leave, and also in regards to payments in lieu of annual leave on termination, which include calculations of how any annual leave had been carried over from previous years. Zero-hours contracts and low-hour contract is also being addressed. These are in the first 8 clauses of the bill, and they set out detailed provisions around 0 hours contracts and contracts with low numbers of guaranteed hours. There's also a new Part 2A that's been introduced into the Employment Rights Act, which is lengthy and complex, so I won't take you through today. But there's going to be a duty to offer guaranteed hours contracts that reflects the hours regularly worked over a reference period. The reference period is yet to be known, but it could possibly be 12 weeks. We hope to bring some more stability to those continued hours. There's also going to be a need to give reasonable notice of shifts. So they'll need to tell staff the date, the start time, the numbers of hours that are to be worked in good time, allowing everybody to prepare better. There's also similarly needs to be reasonable notice if they're going to cancel that shift or make changes to that shift for the same reasons. But as of yet, we don't know what reasonable notice will actually be, and that will be addressed in regulations to come. Looking at what claims can be pursued around this, well, where an employer fails to comply with its duty to provide reasonable notice of a shift or of a cancelled shift, claims can be brought to the ET. Presumably that's going to be within the new 6 months time limit, and compensation is going to be assessed by the tribunals on a just and equitable basis in all of the circumstances. There's no mention of there being any cap on that as of yet. And with regards to automatic unfair dismissal, if the reason or principal reason for dismissal is either the acceptance or rejection of a guaranteed hours offer, or the employer seeking somehow to avoid compliance with the needs to do that, that will become an automatic unfair dismissal, which, as you'll be aware from previous points of the talk, means that there'll be no need to have that 2-year qualifying period, which is soon to be removed, and no need to look at whether there's a light touch approach, because it'll be caught by the umbrella of the automatic unfair dismissal procedures. And also there'll be a right not to suffer a detriment on similar grounds, as in rather than a dismissal, be subjected to a detriment, such as for declining to work shifts where reasonable notice isn't given, or for bringing proceedings against the employer for their failure to comply. So there are changes that have been brought into this. Could have been more, but there still are significant changes. So what's the upshot of it, really? Well, the unions and workers groups, as you'll be aware, have identified a number of areas where it seems that the government has fallen short of some of its manifesto promises, and the impact on collective powers. The right for trade unions to request an access agreement isn't really a right of access, as they said it would be given. It's a right to request it, and if the employer simply chooses not even to engage, it's felt that maybe applications to the CAC don't offer a meaningful remedy with teeth. There are limited changes to prevent the use of unfair practices by employers to prevent statutory recognition. But as you'll have seen, there still are changes, and it is still going to be an easier process to go through. So that in itself, it is positive. Now, there's not going to be any sector-wide collective bargaining, which is unfortunate. But provisions for adult social care and school support staff are subject to tight ministerial control and veto, and don't satisfy any definition of collective bargaining. It also doesn't really prevent a P&O type situation arising in the future, in that there's no provision to actually stop employers or power trade unions by standing together and taking solidarity action to stop those dismissals taking place. But as we did explore, it has increased the tribunal's power to certainly go behind the reasoning given, and to ascertain and look as to whether this was necessary in the circumstances. It doesn't, as we've seen, remove all restrictions on the right to strike that were introduced by the Trade Unions Act 2016, or does it address the restrictions that were introduced as far back as the late 1980s? But as we'll see, it does take away, as we've seen, it has taken away the majority of those more recent ones. So that in itself is a positive step. And even exploring and regulations that are yet to come in with regards to how the steps are taken to make these strikes lawful, a simplification for them is definitely going to be recognised, because hopefully it will remove some of the purposeful pitfalls that were in place to make it difficult to get there in the first place. Key point is it doesn't address the problem of bogus self-employment. At the moment, it doesn't change that in-between gap between employee and self-employed of worker and all the complications that come along with that. And it doesn't outright ban the exploitative use of 0 hours contracts, as we've seen. But it does, as we've gone through, does strengthen it, and it does bring in hopefully more, or will bring in more certainty for people that are working under those contracts, and the ability to plan, should we say, ahead of time more. And whilst it does bring an unfair dismissal as a day one right, as we've seen, there's going to be various exceptions on that, which are yet to be determined, where there's this light touch approach, which will be able to be operated. But again, we don't know all the details. I think the point to be made is this is a fantastic piece of legislation. It's been many years since this amount of changes have been brought in one piece, and it really is a positive step for employees and workers. Not necessarily fully there yet, which is to be expected, because changes of this nature can't be done quickly. So there does need to be things built into it to allow for regulations to be built in over time to bring more changes in. But we'll yet to find out what those are. So not yet perfect, but very, very good is the feelings of it. Which brings me to my conclusion and allowing any questions on the talk. I'm not sure how we want to do this. If I have a look at the chat, I can see that there's some that's been placed in there.
Yeah. Shall I just read them out and you can respond to them, Tony?
That works for me. Thank you. It gives me a break talking for a moment.
Yeah. The first one is a comment from John Dickinson, and it says, John says the law is still pretty toothless with regards to flexible working. If a tribunal can only order a reassessment and compensation up to 8 weeks, if an employer is wealthy, it can just carry on unreasonably declining applications.
Which is more of a statement, but is also not wrong. I mean, we'll see. We'll have to see. There has been changes as we've gone through, and they're certainly positive, because what it does do is there'll be a number of employees that don't want to pay 8 weeks, and in its current form, we've got a day one right to make this request twice a year. So ultimately, if they want to continue doing this, that's 16 weeks of compensation that they might keep paying out every year if essentially they just keep refusing it and be found to be in breach of it. So it's not that it hasn't brought in meaningful changes. And these tribunal judgments, they're public documents. So if you've got large, wealthy employers who are just continuing to do this, what they're also going to be exposed to is possibly 2 judgments a year from the same individual saying you've done it again, which they presumably would be keen to avoid any exposure to negative public press like that. So whilst that is true, I would hope that it actually will have an impact here. And the majority of employers, I would think, wouldn't want to be paying this. They just don't want to claim, because as well as the fact that, okay, the compensation is only 8 weeks, they've got the costs incurred of actually defending those claims. They've got to get legal fees, they've got to go to tribunal hearings, because it's not guaranteed that they can just offer 8 weeks pay as settlement. I mean, we might see that, and they might be making offers of 8 weeks pay and saying this is the most you're going to get. So if you continue with this, we want our legal costs back. Yet to see. But yeah, there are. It hasn't gone as far as it could, should we say? It could have been a scenario where essentially they removed the cap and just said award what's just equitable, and that certainly would have allowed a bit more teeth.
Yeah, thank you very much. A question from Mike Calvert. Any idea when the trade union access rights will actually reach introduction?
The short point is I don't have a definite answer for that. It's not something that's going to come in on the implementation. So it's something that we're going to have to wait and see. understandably, there is quite a lot that is coming in at implementation, so efforts need to be focused on that, with the bill hopefully coming in relatively soon. But I would hope that it's not something that we are going to need to be waiting on too long, and that we will have some more information on that relatively quickly after it's implemented. But yeah, I don't have more information on timescales than on that, I'm afraid.
Okay, thank you. Mike then follows that up with, the rules all seem to be aimed at workplaces with no union or other representation. It could be a right fight if this allows unions to compete in a workplace. Assuming he means with it like a staff association, which we do have in, in the finance sector, in some organisations.
So the rules, when we're talking about the rules, are we talking about, I'm not clear on, maybe Mike could clarify, are we talking about all of the new rules don't seem to be aimed at workplaces with no union representation? Are we focusing still on this access rights?
I thought we were focusing on just on that, the
trade union access
rights, but maybe
clarified it, right?
Right.
I mean, I'm not sure that's necessarily accurate. I mean, what it does do is it brings essentially an ability for unions. So it very much focuses on unions to request that right. It's the trade unions that have that request, that right to request that. And let me just double check. I think I need to double check if that expands to workplace associations, but typically it should fall under the definition. Obviously, we're going to find out the details, but I'd be very surprised if that doesn't fall under the definition of workplace association for them to, like yourself, to request that right to access. The difficulty that I see with that right of access is more it's more that you have to request it as opposed to just being given the right to it. But it's more what teeth is available if employers just choose to ignore it, essentially, because they can simply do that. They can ignore it, or they can enter into negotiations but not have meaningful negotiations and not actually enable you to come to some agreement or not offer you anything that's worthwhile. And then where do you go with that? And it's an application to the CAC, and it's I'm not sure if there's much teeth that will come from that. So I think that's the weakness really with that point. But we'll have to wait and see.
Okay, thank you. Another question from John Dickinson. How do the day one unfair dismissal rights relate to probationary periods? Are they treated the same, or will we see more of them as employers try to get round the changes?
Yes, that's a good question. Again, there's nothing set in stone as of yet, as we saw. It's been pushed back for when that's going to come into place. But as I went through, you'll recall there's the light touch approach. So it seems that these probationary periods. Well, let's start off. There will be a day one right to unfair dismissal. That for employees, there will be that day one right. But then what gets looked at is, well, what procedure needs to be followed by an employer if they're dismissing someone? And the initial consult period that I was talking about seems to be that this probationary period is used. So if within the probationary period, and we don't know for definite what that is yet, but within that probationary period, should we say the dismissal takes place, unless the reason given, so there will need to be a reason given by the employer, unless the reason given by the employer for that dismissal is that it's a redundancy, they will get to do, should we say, a light touch procedure. So they won't need to go through the rigmarole that they would in dismissing somebody when, should we say, they now have 2 years or more service. They can take a lighter approach. So that does obviously mean that essentially what is coming into play isn't that there's the usual unfair dismissal protection that's in place now for employees from day one. It means that the protection for employees from day one during that probationary period is a protection from unfair dismissal, but essentially it's likely that the test that's going to be applied and the steps that need to be taken by the employer to be able to then go and demonstrate it was a dismissal are less onerous than are currently in place for those individuals that have been employed for 2 years. But there are exceptions to that, as we saw. So if the widening the band, the widening the type of cases that are going to be caught for an automatic unfair dismissal, and if it is caught by an automatic unfair dismissal, for which you currently have a day one right anyway, that light touch is out of the picture. It's looking at it under the current traditional rules. And also there is a question mark as to what the redundancy scenario is going to be on that, which we'll have to wait and see. So, I mean, ultimately, there might be a way around it for employers, but it's better than what is currently in place now. And how much better it's going to be is yet to be determined.
Thank you. And then Paul Horsburgh says, great session, thanks Tony. Will the slides be shared, please?
That won't be a problem. I can absolutely share the slides ahead of time. Anya, should I send them on to yourself and let you distribute them?
Thank you, Tony. That'd be great. And yes, the recording will obviously be up on the website for people to view within the next couple of days. And yes, anybody that would like a copy of the slides, if they want to request those, and we can send them out.
Thank you.
Oh, well, thank you very much, everyone, for having me.
Oops.
Sorry, Fiona.
Sorry, Tony. I just wondered if a wee question had come up at one of our meetings, and just thought we'd put it to you. And it's in relation to Northern Ireland. Is there a separate employment bill for them, or how will that work?
Northern Ireland isn't my area. It's also, so I wouldn't want to comment on that. But why don't I send you an email with a little bit more details on that? Would that be helpful?
Oh, that would be great. Yes, thank you very much.
You're very welcome.
Thank you ever so much, Tony. That's been a really great presentation, and I'd just like to thank everybody that's been on the call today as well. And yeah, we'll get slides sent out. And thank you again, Tony. We really appreciate you coming along and doing these updates for us. They're really interesting.
Very, very welcome. Thank you very much for having me. Sorry, it is a bit of a large and dry topic. So thank you for staying involved.
No problem at all. Thanks, Tony, and thank you to everybody again for joining today. We'll be in touch with further seminar updates through the newsletter, as we always do. Have a good day, everybody. Bye.
Thank you.
Bye.
Bye.